quashed the conviction and sentence and substituted a conviction for attempted rape. Dissatisfied, the accused further appealed to the Supreme Court. The Supreme Court observed, I that there was no evidence of age of the prosecutrix, that her hymen was torn during the alleged rape or whether or not she was a virgin too. That there must first be proof of penetration. 3. That penetration of the vagina must be linked with the appellant irrespective of whether the prosecutrix was a minor or an adult. Absence of such evidence was fatal to any charge of rape. The Supreme Court also considered the conviction for attempted rape as unfortunate, adding that to constitute an attempt, the act must be immediately connected with the commission of the particular offense charged and must be something more than mere preparation or the commission of the offense. C. R. v. Eagleton. 1855, Ozigbo v. Kopp. 1936, and Orajar v. IGP. 1957, where the other ingredients of rape are present but the facts of penetration is lacking or cannot be proved, the accused may be convicted of attempted rape. 3.7 Evidential corroboration in sexual offenses. There are certain sexual offenses with which the accused cannot be convicted upon the uncorroborated testimony or evidence of one witness. These are offenses bordering on defilement of a girl under 13. See Section 218 of the Criminal Code. For defilement of girls under 16 and above 13 and idiots, see Section 211 of the Criminal Code. Procuration of a girl or woman for unlawful carnal knowledge or for prostitution whether in Nigeria or elsewhere, see Section 223 of the Criminal Code, and procuring defilement of a woman by threat or administering drugs. See Section 224 of the Criminal Code. In other sexual offenses where the law has not specifically said the accused cannot be convicted upon the uncorroborated testimony of one witness, the courts are reluctant to convict upon the uncorroborated. CSS 152. Introduction to Nigeria Criminal LA. W. 83. Testimony of a complainant. It is not a rule of law that an accused person in a charge of rape cannot be convicted on the uncorroborated evidence of the prosecutrix. But it is an established practice in criminal law that though corroboration of the evidence or the prosecutrix in a rape case is not essential in law, it is in practice always looked for, and it is also be practice to warn the jury, or the judge to warn himself, against the danger of acting upon her uncorroborated testimony, or that it is unsafe to convict on the uncorroborated evidence of the prosecutrix. I. Beacon Mar v. The Queen. 1963, the court may, after paying due attention to the warning, nevertheless convict the accused person if it is satisfied with the truth of her evidence. The reluctance of the courts to convict upon uncorroborated testimony of one witness is not predicated on law but on a rule of thumb or practice. But the court may, after warning itself, nevertheless convict on an uncorroborated evidence of a prosecution if it is satisfied of the truth of her evidence. See the cases of Summon U v Police. 1957, WRNLR 23/24 and R v Klagu. 1960, 5 FSC 217. The danger sought to be obviated by the requirement of corroborative evidence is that the story told by the prosecutrix may be deficient, inaccurate, suspect or incredible by reasons not applicable to other competent witnesses. All that is required is confirmation and support from some other source that is sufficient, satisfactory, credible and corroborative that the suspect witness is telling the truth in some part of her story, which goes to show that the accused person committed the offense with which he is charged. Corroborative evidence merely goes to support or strengthen the assertions of the complainant. It is not enough that the evidence tends to corroborate any part of the story told by the complainant. It must corroborate substantially her evidence. Indeed, it is trite law that evidence in corroboration must be independent testimony, direct or circumstantial, which confirms in some material particular not only that an offense has been committed but that the accused has committed it. On a charge of rape, therefore, the corroborative evidence must confirm in some material particular that sexual intercourse has taken place. 2. It took place without the consent of the woman or girl, and 3. The accused person was the man who committed the crime. Lord Reading summed up what evidence constitutes corroborative evidence this way: corroboration must be independent testimony, which affects the accused by connecting or tending to connect him with. CSS 152. Introduction to Nigeria Criminal LA. W. 84. The crime. In other words, it must be evidence which implicates him, that is, which confirms in some material particular not only the evidence that the crime has been committed but also that the defendant committed it. The test applicable to determine the nature and extent of the corroboration is thus the same whether the case falls within that class of offense for which corroboration is required by statute or as a matter of practice. 4.0 Conclusion. Rape is a crime, and in this unit we have explained the requirement for liability for certain sexual crimes by considering the possible liability of an accused for rape, attempted rape, etc. We have been able to explain the punishment for rape and attempted rape and how the crime of rape can be proved in the law court. 5.0 Summary. Consent to intercourse with a woman amounts to no rape. If the woman does not consent to the offense, rape is committed. If the consent is obtained either by force, threat, intimidation, impersonation or misrepresentation, there is not consent at all. The offense of rape is complete upon the slightest penetration of the penis into the vagina. The accused must have the capacity to commit the offense. 6.0 Tutor marked assignment 1. If a beautiful lady whom you have been admiring walks down your office in her nakedness, and having been thrown into a romantic trance, you pounce on her, throw her on the ground and without her consent, you now have a sexual intercourse with her, have you committed the offense of rape? 2. In Nigeria, the law is that the offense of rape is complete upon the slightest penetration of the penis into the vagina. What happens if a person cheers up the accused who has already achieved penetration and who is now working towards ejaculation? 3. Is there any justifiable ground why it could be said that a man cannot rape his lawful wife? CSS 152. Introduction to Nigeria Criminal LA. W. 85. 7.0 References / further reading. G. Fletcher, Rethinking Criminal Law. Okonkwo C. O. and Naish, 1990, Criminal Law in Nigeria. I. Baden, Spectrum Law Publishing. Smith and Naish, Criminal Law, Cases Material. CSS 152. Introduction to Nigeria Criminal LA. W. 86. Unit 5 Theories and Types of Punishment. The essence of this unit is to acquaint you with the theories and types of punishment. If the court finds the accused person who was standing trial before it to be guilty of the offense for which he is being charged, the court will then decide on the type of punishment to visit on the accused persons, depending however on the provision of the law. This unit is treated thus: Contents 1.0 Introduction, 2.0 Objectives, 3.0 Main Content, 3.1 Retribution, Fair Deserts, 3.2 The Idea of Responsibility, 3.3 Utilitarian Purpose of Punishment, 3.4 Disablement, 3.5 Deterrence, 3.6 Rehabilitation, 3.7 Educative Principle, 4.0 Conclusion, 5.0 Summary, 6.0 Tutor marked assignment. 7.0 References / further reading 1.0 Introduction. The essence of punishment in a criminal trial is to subject the accused to some form of deprivation in as much the same way as it will also satisfy the aspiration of the complainant. The punishment to be meted out by the court is not at the whims and caprices to the court. The court itself is guided by certain principles while awarding punishments which are treated in this topic. The court will also look at the sanction provision of the enactment which creates the offense in question. 2.0 Objectives. At the end of this unit, you should be able to state theories of punishment, explain the principles behind the theories, explain the notion that liability can only lie against the accused, give the reasons for the various theories, explain the viability or otherwise of the theories. CSS 152. Introduction to Nigeria Criminal LA.W. 87. 3.0 Main content. 3.1 Retribution, Fair Deserts. Under this heading, the punishing authority looks back at the circumstances of the crime committed and decides what type of punishment the accused deserves for his conduct, having regard to his responsibility for the crime. This approach involves retribution or the wreaking of vengeances and infliction of injuries by society on behalf of their injured individual, on the wickedness of the offender. Therefore, punishment is imposed in order to relieve the indignant feelings of the public, or it could be imposed to mark the level of revulsion with which the public regards the crime. The purpose of capital punishment contains the notion of extra punishment, which is also implicit in hard labor as distinct from ordinary imprisonment. This stems from the feelings that a more wicked man should suffer more severe pain. The effect of retribution may be that the offender, by undergoing punishment, is offered a chance to expiate, make amends for his wickedness, to relieve his conscience and to pay for what he has done. Since retribution is essentially a non-utilitarian principle, it cannot be disapproved but only accepted or rejected as a matter of emotional preference. In retributive, backward-looking punishment,